All right, so let's move to the next belt of our conversation. I mean, this review has been signed, sealed, delivered by the Apex Court. But let's talk about the Assin North seat. So we've had the initial decision, I mean, from the Cape Coast High Court through the Court of Appeal stage. And Bobby Banson, you heard the other time when we had this interaction, the clarity that was given you. And now landing with a substantive case at the Apex Court. Justice, maybe before you take leave of us, I want your take on this as well. James Quayson is back in court for two reasons. He wants the injunction imposed on him in terms of not performing his parliamentary duties revoked, so to speak. And he also wants the substantive case against him at the Supreme Court thrown out. Looking at all that we've seen up to this point, how do you feel this is going to pan out? I mean, is it going to be any different, the decisions that the courts have given as of this point? And how possible do you feel the revocation of the injunction is? Do we have Justice with us?
Yes, I'm here. Sorry, I didn't know it was in reference to me.
So that question was for you.
Oh, very good. So can you then repeat the question? Because I thought we were still dealing with just like with Attorney General.
So we're done with your case, the review case, and we're moving on to the next leg, which has to do with the James Quayson bit. I'm saying that on the back of what has happened from the High Court to the Court of Appeal to the Supreme Court, with all that we've seen, and now with the positioning of the legal team for James Quayson, that the injunction against him in terms of performing his role as a member of Parliament should be overturned. And then again, that the substantive case at the Supreme Court should be thrown out. I mean, when you digest the issues, what do you see happening? I don't want you to shoot the court in terms of what they will do, but looking at all that we've seen so far, is this something that likely could lead to any overturn?
If you look at the antecedents of Mr. Quayson's case, Honorable Quayson's case, it looks to me that almost all the foundations have fallen. And so it will be very difficult to put something on nothing. I think it's a very difficult case at this moment. If you remember, I strongly urged that they file the review of the injunction application, because in my mind, I could not really understand the basis for the Supreme Court's decision to injunct a member of Parliament from performing his constitutional obligations. I still stand by that. I think it's not a good practice. I think the Supreme Court could have done way better in that by maybe probably laying down the necessary principles that would guide all of us going forward. Because really, I seriously think, if you look at our constitutional history, hardly would you find the Supreme Court injuncting a constitutional body from performing its constitutional mandate, or indeed any other court. It hardly happens. And that's why you can never, for instance, find the state being injuncted, particularly the executive being injuncted in the performance of its duties. Imagine tomorrow we wake up to see that maybe out of an election petition, when the petitioner files an application injuncting the certain president from continuing with the performance of his duties on the basis that he was wrongfully elected or by virtue of the writ that was issued. I do not think this would even...
But there are processes to follow in that instance. There are processes to follow. We saw it in 2012. We saw it in 2020 as well.
Yeah, but we never witnessed any application for an injunction on the elected president from continuing with the performance of his duties. So my question is, let's just imagine the possibility of that happening in future, and the petitioner filing for an injunction on the elected president on the basis that the election was wrongful, and so on the basis on that ground, his continuous performance and existence in the office being illegal, he should not be allowed to perform his constitutional mandate as a president. I think, if you can fathom some of these possibilities and come to a particular conclusion, then you should understand my position that injuncting a member of parliament from performing his constitutional obligation is something that you easily not give in. At least not on the basis of he being an unlawful candidate in that office. And once again, this being a review application, I was in court yesterday when the case was called, and his lawyers were present, the AG and everyone else was there. It was obvious from where I said that it's a very tall order for the applicants in this case, and it makes it's even more difficult because the appeal that was filed was thrown out, and so it's not going to be that easy. We cannot guess what the Supreme Court will be coming out with, but I would hope that the Supreme Court comes out with a reasoned decision that would be of immense help to all of us going forward, particularly as a guide on some of these matters I'm raising. Because I know tomorrow, based on this Quayson's case, there would definitely be, if we happen to have an election petition, an application to restrain the president. It's going to happen one day in this our republic. And it's going to be a very difficult decision for the Supreme Court to make, particularly when they have already made this injunction application. But this is going to be a precedent for future applications on constitutional bodies, particularly members of the executive and the legislature. So it is the reason why we must be guided by the Supreme Court in future applications with this review, so that they can give us something solid for us to be guided by.
All right. Justice Abdullahi, thank you so much for joining us for this conversation this morning. We are immensely grateful for the time you spent with us.
Absolutely. For God and country always.
Thank you. I'll come to you, gentlemen, Gary and Inusa Fusedi. But first, let me do lawyer Bobby Banson, who I know you have to take leave of us shortly. So, Bobby, your quick take on this matter, the two-pronged matter of the injunction that Judge Quayson wants lifted and the substantive case at the Supreme Court that he wants thrown out. Your quick reactions.
I because of the internet connections, I've had to put off the video for some stuff.
Understandable.
I don't know if it's better now. I have seen the process that has been filed.
Right.
Invoking the inherent jurisdiction of the Supreme Court. I've been going through the Supreme Court rules. I want to find. I'm not sure if it's the best approach, because the rules of the Supreme Court sets out the way in which you can even challenge the jurisdiction of the Supreme Court. You would have to file your defense memorandum of issues would come out, and if there is the jurisdiction of the court, it's not treated like the High Court where you can bring an application to invoke the jurisdiction. And so I want to.
Hello, Bobby. So I'm just waiting to see whether maybe the connection of Bobby Banson would become a bit better, because he was basically wrapping up on his comments there. Bobby Banson, can you hear me? All right, it appears it's still problematic. When we do get him, if he has the time to be able to wrap up, he will do so. But Gary, in that other issue, which is of major concern to your party, I've heard John Bwedu, the General Secretary, talk about the fact that you're already preparing for a by-election, though, I mean, the green light hasn't been given by the Supreme Court for that, and of course the EC has to come in. But with these new writs that have been filed by the Judge Quayson team, do you feel they could put an impediment in that process in terms of preparing for a by-election?
Well, but let me say that I have a major difficulty with the argument and the reasoning of my brother Abdullahi on this particular matter.
Right.
You see, as lawyers, I think sometimes we must not confuse the public. There exists a judgment of a high court. There exists a judgment of a high court which has not been impeached. It's not been set aside. It's not been vacated. The judgment is still valid and subsistent as we speak. An appeal was filed in the judgment. A stay was filed in the judgment. It froze the judgment. Along the line, the applicant did not pursue the appeal. All the applications that were on the process were all dismissed. Appeal struck out. The judgment stands as a valid judgment. You see, we shouldn't confuse the public. Now, when a judgment is there, and the judgment has ordered that go and rerun an election, declared you that your election was invalid, and all those things. And then, as part of an application for injunction to be considered by a Supreme Court, they have a regard to this particular judgment. And then you say that the Supreme Court was given a bad precedent by injuncting the person. What is a matter of fact? There is already existing an injunction order, perpetual injunction. And until the judgment is vacated, that judgment is still, it has to be enforced. So, you see, I don't think that it is good for sometimes for us to confuse the public by making them believe that, you can just file an application for injunction out of nothing and the court will grant it. I don't think you should confuse the public at all. And then you say that, in future, somebody will file for presidential petition and then will bring injunction to enjoin the president. This case is a different matter. There is a valid judgment. So please, we shouldn't confuse the public at all. Now, I have always maintained that nothing stopped Mr. Quayson and his lawyers from pursuing the appeal at the Court of Appeal. So if for some reason we didn't comply with the conditions of an appeal has been struck out for non-compliance, why do you turn around to blame any other person? By you don't blame your lawyers who were supposed to have filed your documents for you to pursue the appeal at the Court of Appeal. So you see, some of these things, really, I don't think that we have to, confuse the public at all. It must be very clear for everybody to understand that as it stands, there already exists a valid judgment of a high court.
So for you, as far as you are concerned, these new rates will fail in court?
Say it again.
So as far as you are concerned, these new rates will not amend anything. They will not change anything. In fact, they will fail in court.
Oh, I can never say that. Don't be putting words in my mouth. I'm not a judge in the Supreme Court.
I'm only posing a question. I am saying...
No. I'm not one of the people that want to always overreach a court of law and make predictions before the time. You understand the thing?
Right.
If you have a case in court, you file a process before the court, you go and defend the matter before the judges. If you go and they agree with you, that is fine. If you go and they don't agree with you, it's another matter.
All right.
You see? I think he's having his day in court.
Right.
I think pursue all that you pursue in the court. At the end of the day, if the court should come with a decision, that should be it. That is all. But as it stands now, the status quo now is that there exists a valid judgment of a high court, which has not been impeached. It's not been set aside. It's not been vacated. You see, and you cannot choose which judgment to obey, which not to obey. You cannot choose that I will obey here and I will not obey here. No, you can't do that. You see, so it is very clear. So when you are trying to explain to the public as a way of a public education, and then you say that, somebody will file a petition and bring an injunction on the back of it, as if the injunction is brought upon nothing. No. I think we should try and let the public know the status quo as it stands now. What is it now? What it stands now is that on the back of the injunction that was filed at the Supreme Court was simply that there was also a valid judgment that was subsisting, which the court had to have regard to. And no court of law having regard to a high court judgment will close its eyes and say that they will not look at it. No, they will not do that.
So that point is clearly made from your quarters. But maybe to wrap with you, your party says it is gearing up for a by-election. You've lost back-to-back in Assin North. And though in the past you have also won in that constituency. But you look at the difference, 2016 and 2020, you lost a whole lot more votes in the 2020 election, which points to the fact that even if the by-election were held, the possibility of the MPP taking the seat would be very dicey. How optimistic are you?
In politics, they even change the dynamics in politics. What probably might have led to the party losing Assin North maybe different various factors. Now they're also doing their own homework and doing their own permutations and their own consultations. I believe that if the party put on the right structures and then correct the mistakes or the errors that it made in the 2020 elections, I think things can change. Things can change. I mean, what led to the election being lost in Assin North is not the same thing as it stands now. So I believe that things can change.
So you believe your party stands a better chance now?
I believe so. But the way is not clear yet. You see, in view of all
okay,
it's still not clear. Now, if the way clears, and then there is no other pending matter at the Supreme Court or any other court, I believe that the EC can declare the seat vacant. We can make some progress and go for the by-election.
All right, Gary, thank you so much for connecting with us, and we'll see how things pan out should that by-election be held. Let me wrap with Innocent Husseini.
And let me greet my senior honorable Innocent Husseini. It's a long time I saw him.
Gary, I'm fine.
I greet him. And I miss you. You know.
Yeah, thank you.
Have a good day.
All right. Have a good day too, Gary. Innocent, right. So you'll get the final bite. How hopeful are you of these new processes that have been filed? And what would you expect in case a by-election were held?
Well, so let's try to unpack some more. First of all, I heard Bob Banson say that he does not understand the process the applicant has used in this particular case, invoking the inherent jurisdiction. Inherent jurisdictions of courts are jurisdictions that are general. Courts exist to do justice. And so when there is no specific rule dealing with a matter that can bring you justice, that can secure you justice, you invoke the inherent jurisdiction of the court because they exist to do justice. And so what the application tells me is that probably there's no specific rule of the court that deals with invoking the jurisdiction of the court to set aside an interlocutory injunction, and that is why they have gone under the inherent. To and how the court will decide that application is a matter entirely within the purview of the court. We cannot prejudge. To the jurisdiction is very important in any matter, whether you are in the lower court or you're in the higher court. In fact, if you look at the elements of the rule of law and checks and balances, jurisdiction is actually in one vein a check. Where the court has no jurisdiction to entertain a matter, it's a limitation on the jurisdiction of the court. It's a limitation on the power of the court. So the Supreme Court has got, the jurisdiction of the Supreme Court is spelled out in the Constitution. Original jurisdiction in matters of the enforcement of human rights and the interpretation of the Constitution.
Right.
Exclusive jurisdiction in the exclusive original jurisdiction in the interpretation of the Constitution. Now, in appellate jurisdiction or matters originating from the lower court. Now, so if you bring a substantive matter to the Supreme Court, and that Supreme Court shares jurisdiction with a lower court on the same matter, you have to start your action in the lower court.
Right.
Okay? So, put in another way, where the Supreme Court shares
So I think,
jurisdiction.
Honorable Husseini, for the sake of time, we've walked through the processes and what ought to be done. But I just wanted to find out, just to conclude, like I posed the question to you, how optimistic are you that you can retain the Assin North seat should there be a by-election?
MPP knows that, and Gary knows that, and John Boyd knows that, and the pollsters have said it, that look, it will be much ado about nothing. When we get there, if a push comes to shove and the seat is declared vacant, because I'm not sure we have gotten to the end yet, but if we do get to the end, and then the decision of the High Court is allowed to stand, and a vacancy has been declared in Assin North, NDC will take it.
All right.
NDC will take it.
Thank you, Honorable Husseini, for joining the conversation. Former Member of Parliament for Tamale Central, and also a member of the legal team of the NDC. We also had Gary Nimako joining Justice Abdullahi and Bobby Banson.